Era of unregulated exploitation. The 17th century marks the beginning of exploration by settlers in BC. In 1825, the Hudson Bay Company began settling in the Pacific Northwest. By 1846, the Oregon Treaty boundary established the 49th parallel as the U.S.-British boundary. In 1849, the Crown Timber Act attempted to consolidate previous legislation by enforcing payment of ground rent and timber dues. In 1867, the Confederation of Canada is formed, and by 1871, BC joins Canada. During this period, Joseph Trutch declares BC empty land or terra nullius and stops the further settlement of treaties in BC. As a result, the Indian reserve size was reduced by 90% and prohibited the preemption of land by First Nations. In 1876, the federal government Indian Act was put into place. Between 1880 and 1951, the implementation of residential schools and banning of potlatches would have severe negative consequences and impacts on many Aboriginal communities in Canada. These negative effects would last for generations and generations to follow. Regulation of revenue era. This era was marked by the regulation for profit and revenue enhancement of the Canadian government. In 1888, the Land Act in British Columbia was created with specific forest and tenure licenses and policies. This led to the introduction of stumpage and ground rents. In 1901, the Order in Council made further amendments and required licensees to operate a sawmill for at least 6 months of the year to secure local economies. Conservation era. In 1945, the Sloan Commission took place. It addressed certain issues such as the sustained yield policy, massive industrial investment, and area-based tree farm licenses. It should be noted that the rewritten Indian Act did not include the previous section on timberlands, but instead stated that timber licenses could be granted from surrendered or reserve lands. During this time, First Nations were still prohibited by the federal government to hire lawyers to discuss the land question. Furthermore, 1954, the first Indian timber regulations were promulgated and remained the only management regime which applied to reserve lands. These regulations provide for the insurance of timber permits to a band or band member for 1-year renewable licenses. Post-World War II in 1951, the United Nations Declaration of Human Rights led to the removal of many oppressive sections of the Indian Act. 1973 was a historic moment for many First Nations because it was the year that the Calder case was settled and Aboriginal title was re-established in the Confederation. Forest Management Era. In 1976, the Pierce Royal Commission, later known as the 1978 Forest Act, was put into place and instilled export controls, opportunity transfer restrictions, and cut controls within the forestry sector. In 1985, during the War in the Woods, the Haida Nation took direct action against McMillan and Blodell and resulted in the imposition of a growing number of forest practice rules on tenure holders. However, the fundamental timber paradigm still remains the same, which is up for debate today. We now enter the sustainable management era, or present day, where we are seeing an increasing trend towards more sustainable forest practices and increased involvement of Aboriginal peoples in forest management practices. Furthermore, in 1993, the Tlaoquat and Aswat First Nations filed an injunction against old-growth logging in Vancouver Island, and following suit, Greenpeace launched a consumer boycott campaign which led to the Cliquot blockades and 800 people being arrested. This led to the Cliquot Sound Scientific Panel making several recommendations which included the use of traditional ecological knowledge. 1997 was another landmark year for First Nations as the Dalgamut case was settled and Aboriginal title was defined. Just recently, in 2014, the Chilcotin First Nations won their first case and secured their right to joint decision-making processes regarding natural resource management on their traditional lands. In conclusion, we can look forward to a brighter future ahead with increasing communication between First Nations and the Crown with regards to natural resource management decisions in Canada.